The third and last category of debts that can end up not being discharged in a Chapter 7 are in the materials. Sometimes when we say a debt's not discharged, we use the term that it is accepted from discharge, or it is an exception from discharge. The end result is the debt didn't go away. You're not discharged of that debt. Now, Chapter 7, the last category in a Chapter 7 is what I referred to as that nuclear bomb of bankruptcy. Rarely used, but if used correctly, it has devastating consequences to the debtor. And that's under Section 727 of the Bankruptcy Code. And if I might just go back, that second category that we just finished discussing, that's under Section 523. Section 727 is a different animal. It's a different theory. And that is where a judge can say not one single debt gets discharged in the bankruptcy because the debtor did bad things as against the bankruptcy court or as against the bankruptcy system, either in preparation for the bankruptcy or during the bankruptcy. It's different than as opposed to committing a fraud on one specific creditor. And again, the complaint has to be filed within 60 days after the meeting of creditors. And again, the debtor is entitled to a trial in front of the judge. This is one where the complaint may be filed by a creditor or the Chapter 7 trustee. In the prior category, the ones involving fraud and false pretenses and all that, that would only be the creditor would file it. The trustee wouldn't care because the trustee is not out there to file lawsuits on behalf of a specific creditor. But in category number 3, a trustee or a creditor can file this complaint. Well, what is the misconduct that could give rise to one of these complaints? Well, the first one is, did the debtor transfer, conceal, or destroy property of the debtor in the 1 year before filing bankruptcy with the intent to hinder, delay, or defraud a creditor or the bankruptcy court? The debtor, knows that the debtor's in debt. The debtor knows that they might be going to file bankruptcy, and they give their $10,000 diamond ring to their sister. Why do they do that? Because they don't want it to go to the bankruptcy court. Well, that's probably a transfer with the intent to hinder, delay, or defraud creditors in the 1 year before bankruptcy. The result can be that the bankruptcy judge says not a single debt gets wiped out, and the trustee can go get the ring back from the person who got it, or can go sue that third party to get the money back if the ring's been sold. So that's why you have to be very careful about what you do before bankruptcy. And that's why, as a paralegal and as an attorney, I have to very carefully, you as a paralegal, me as an attorney, have to very carefully question the clients, because sometimes they've done this stuff and not even realize what they've done. Sometimes it's inadvertent, and maybe they didn't have a bad intent. Maybe they had bad intent, but they don't realize they had a bad intent. Sometimes you can wait out the 1 year period, and maybe file the bankruptcy after more than a year later to get around that problem. The second one is somewhat related, and that is, after the bankruptcy is filed, did the debtor transfer, conceal, or destroy property that belonged to the bankruptcy court with the intent to hinder, delay, or defraud the court? Let me give you an example. The debtor files bankruptcy, and the debtor's got a boat. Let's say it's worth $10,000 and it's free and clear. And in Arizona, we can't exempt or protect boats. It's not allowed. In Oregon, you can if you live on it. You can put a homestead on a houseboat, but that's a different story. So let's say the debtor's got this boat, and the debtor realizes that the bankruptcy trustee is going to come get the boat. And the debtor, out of just spite, sets the boat on fire or sinks it. Just like, well, heck, if I'm not going to have it, nobody's going to have it. Well, that's destroying property with the intent to hinder, delay, or defraud the creditor or the court. Same thing if you hide, conceal assets, that can result in not one single debt being discharged. Again, you stay in bankruptcy, the case is not dismissed, the trustee can still go after other property, the person comes out of bankruptcy with the bankruptcy in the record and not one single debt wiped out in that bankruptcy. The next one is concealing or destroying the debtor's financial records. The trustee is entitled to look at the debtor's financial records, particularly in business cases, but in consumer cases they can ask for that. Bank records, checking accounts. You can't destroy that stuff if that's done with the intent to conceal something. The next one, lying in connection with the bankruptcy or attempting a bribe of a bankruptcy official. This is the one that people can get nailed on. They fib in the bankruptcy paperwork. The bankruptcy paperwork asks them detailed questions, over and over to cover every possible thing they own, every possible thing they've given away within certain time periods. Those have to be answered accurately. And if people intentionally don't tell the truth in the paperwork or at the bankruptcy hearing or in any hearing under oath, or they try to bribe a bankruptcy official, that can result in a lawsuit, an adversary complaint, and if the judge is convinced those things happened, then that person may be denied a discharge of all of their debts. And the FBI could also file a criminal case and prosecute you for bankruptcy fraud in criminal court, and you could also go to prison for 5 years. And one of my favorite stories, and I read this some years ago, was a person who was growing marijuana in the person's basement. Now, this was before medical marijuana was legal. Okay, so we're going to assume that this marijuana is totally illegal and not allowed. And this person had an elaborate lighting system and hydroponics. This person files bankruptcy. Of course, they don't list any of this equipment in their bankruptcy. They're not going to put in their bankruptcy that they're growing illegal marijuana in their basement. But by not listing it in their bankruptcy, they have just committed the offense of not being truthful in their bankruptcy records. So they can be denied a discharge of all of their debts. And what happened in this case was, for other reasons, the house was raided by the police, not related to the bankruptcy, but related to the drugs. Of course, they found all of this equipment. That got reported to the bankruptcy court. So the person ended up having criminal charges for growing marijuana. They lost their discharge in the bankruptcy, and then they probably were prosecuted for bankruptcy fraud also. And that's an example of how you could violate that section. The next one is refusing to turn over financial records, not destroying them, but just not turning them over. If the trustee asks for your bank statements, checkbooks, whatever, tax returns, you got to turn them over. The next one is failing to reasonably explain the debtor's financial situation or any missing property or money. This is for those situations generally where you have a debtor that's gone through a lot of cash within a short time before bankruptcy, and they just don't seem to have any records of where that money went. Well, if you want the relief of a bankruptcy, it's the obligation of the person filing bankruptcy to have reasonable records to show where the money went, or if they were running a business, to show that there are business records. It's not enough to just say, gee, I don't keep records, or I don't know, or gee, maybe I gambled it away, but I just don't know where or when. Because if you can't explain it, then maybe you still have it, maybe you still have the money, but it's your obligation to be able to reasonably explain your financial situation if you want the benefit of a bankruptcy. Again, that tends to come up more in business cases or cases involving cash or mysterious missing assets, but it does come up from time to time. So a business person better have some books. They don't have to be great books, but they better have some books. The next one has to do with refusing to obey a court order or answer a question in a bankruptcy unless it's justified by the right to remain silent under self-incrimination. In other words, the debtor just can't say, well, I'm not going to answer that question. They have to have a legitimate fear that it could incriminate them in some criminal case. I will tell you, in my 31 years, I have on 2 occasions advised debtors at meetings of creditors to take the Fifth Amendment. It's not something I like to do, but fortunately I have some criminal law background, and I knew there were creditors there who were trying to get my client in criminal trouble, and so the best thing to do was to have that client simply take the Fifth, and I've done it. So you can't just refuse to answer a question because you don't want to. The next one has to do with a financial management course. Part of the changes in 2005 required that before a debtor filed bankruptcy, they have to take what's called a credit counseling class. Now, that's not what we're talking about here, but you can't file bankruptcy now unless you take what's called a credit counseling class before you file bankruptcy. And then after you file the bankruptcy, but before you can get a discharge, you have to take this other class called a financial management class, or we call it the debtor education class. You can do it online. It costs about $20, and you get a certificate saying you've completed that. It basically is how to manage a budget, how to stay out of debt in the future. The concept actually was borrowed from Canadian bankruptcy law. If you don't do that second class, you're not going to get a discharge. And as a paralegal, that's something you will be learning how to mark on the calendaring system so that it pops up to check, did Mr. and Mrs. Smith do their class? Believe it or not, there are people who won't do their second class. And you call them and you write them and you say, if you don't do your class, you're not going to get your discharge. You give them all the information on how to do it. And you know, it's hard to explain, but some people just don't do it. And guess what? They don't get a discharge because they went to a silly online class for $20. And by the way, you can't flunk the class. Anybody can do the class. And the last one has to do with certain felonies having to do with security violations or serious physical injury or death. I don't want to go into that. It's pretty rare. Those are the debts that don't get discharged in a Chapter 7. In the materials is a Chapter 7 distribution chart that shows, and I'll hold it up here for the camera, it shows how money is distributed in a Chapter 7 if it's one of those 10% or less cases where the trustee does come into some money or some assets and distributes it. It explains how exempt property goes back to the individual debtors, and it sort of gives you an idea how this works. Again, in most cases, trustees don't take anything in a typical Chapter 7 bankruptcy. The next page in those materials is an outline of what are called the unsecured priority claims. Those are the claims that the Chapter 7 trustee pays first if there is any money to distribute.